Thanks for joining me on my review video. This review video is going to go over some of the Supreme Court cases, the four that we discussed in class. Wanted to give you some extra information on those so that you're prepared for our exam tomorrow. Just so you know, if you took the time to watch this video, I want to let you know I appreciate any extra effort you guys put into studying. If you post a response under the announcements, I'll have an announcement talking about this video tonight. If you go back to that and post a little comment, I'll give you extra credit on the test. Okay, so you'll get one additional point there. So make sure you take advantage of that. After you're done watching this video, just go back to the announcements page on my big campus. There should be a post from me. Just respond to that in some way, say something, whatever, I don't care. And I'll give you extra credit on your test for that. Let's go ahead and get started. The four cases we're going to talk about are Tinker v. Des Moines, Hazelwood School District v. Kuhlmeyer, Plessy v. Ferguson, and Brown v. Board of Education. First up, Tinker versus Des Moines. It's a court case where a couple students wore some armbands that protested the Vietnam War. Teachers didn't like that. The principal didn't like that, thought that there was a disturbance to the school, so the principal went ahead and suspended the students. The students responded by filing a lawsuit stating that it was an infringement on their freedom of speech. Okay, so the issue in this court case is freedom of speech, the First Amendment, and also freedom of expression, really. It falls more along the lines of that. Okay, so principal suspends the students take it to the court. The Supreme Court ruled in favor of the students. It said there was no evidence whatsoever of interference with the schoolwork or with the rights of others to be secure or be left alone. So the court ruled in favor of the students here. The significance of this particular court case is that the court case limited the powers of school to completely control speech. Alright, so it took away some of the powers from schools. It made it so that students within school, and one of the terminology they use is that students don't lose their rights once they pass the schoolhouse gate. Which means once you walk into school, you do not completely give up your freedom of speech. You do have the same rights to freedom of speech and freedom of expression. A quote from Justice A. Fortas is, "In our system, state-operated schools may not be enclaves of totalitarianism." What that means is that a school cannot be in the middle of a democratic country. A school cannot be a place where there's a totalitarian dictatorship. I always joke that I'm a dictator in the classroom, but in reality, you all still have rights. School officials do not possess absolute authority over their students. That's how he finished out the quote. So this is a case where the power of schools were somewhat limited. All right, and it was a victory for students and for freedom of speech in general. On the other side of that, we have the court case of Hazelwood School District versus Kuhlmeyer. The main points there was that a couple students had written a news article that was to appear in their paper. One article dealt with teenage pregnancy, and the other article dealt with divorce, and the students said some slanderous or harmful things about their father. The principal removed the stories and deemed that they were inappropriate for the school setting. All right. The issue there was, once again, the freedom of speech, infringement of freedom of speech, and the First Amendment of the Constitution. The court ruled in favor of the school in this case. Okay, so they took the other side in this particular case. They did not uphold, or they did not side with the students. They sided with the school and said that the school had every right to do that. Talk about the significance here. All right, it gives the schools power over students' freedom of speech in order to promote educational goals of school. One of the arguments they made in the Kuhlmeyer case is that the newspaper class was a school function, a school class, and that the articles were to pertain to the school curriculum. So they did not have freedom of speech to talk about whatever they want. It had to be within the objectives of the school and what they wanted wanted their students to achieve. So once again, this is a court case where some of the power shifts back in favor of the schools, and it does give schools the right to determine what does hinder the learning process and what doesn't. And that's where you see a lot of schools, they'll talk about things like school uniforms, the clothes that kids wear. Does that affect your ability to learn? And if a school can determine that it does affect your ability to learn, they can dictate a dress code or limit some of the things you can wear. and then it goes along with expression, goes along with speech. You obviously know you can't say whatever you want in a classroom because many of the things you might want to say could hinder the learning process, and that would be a situation where a school could punish you, and it would be completely within their rights, and it would not be in violation of the First Amendment. Moving on, we have Plessy versus Ferguson. So we're kind of moving away from the First Amendment and moving towards the 14th Amendment. Both of these next two court cases took place after the Civil War and after the creation of the 14th Amendment, which protected the rights of all citizens, but in particular was meant to protect the rights of African Americans. The main point of Plessy versus Ferguson was that law required railroad companies to provide separate cars for black passengers. So this was segregation. Okay, they were segregating the population. White citizens would sit probably towards the front of the train in nicer, more luxurious train cars, and there'd be separate ones for blacks in the back. One particular citizen, Homer Plessy, an African American, tried to sit in one of the white cars. He was told he had to leave. He could not sit there. He and a group of other African American leaders sued the train company, Ferguson, under the guise of violation of the Equal Protection Clause of the 14th Amendment. They took it all the way to the Supreme Court. Supreme Court ruled in favor of Ferguson, in favor of the train company, that they were completely legal in doing that. And they stated that separate but equal did not constitute discrimination. That separate but equal, while it was segregation, was perfectly legal and perfectly tolerable under the 14th Amendment. That it was equal protection because it's separate, but the conditions were still equal, even though they may not have in reality been equal. The significance of this case, this set the precedence of separate but equal. All right, so from now on, from 1896 when this took place all the way into the 50s, the idea of separate but equal was tolerable in the United States. The idea of basically segregating the population and creating areas where only white people can go and creating areas where only black people could go was completely tolerable, and in fact it was constitutional. All right, it made legal segregation. Okay, and this will remain the standard for over 50 years. So Plessy versus Ferguson really set up that idea of separate but equal and legalized segregation in our society. And you would see that all the way up into the 50s until we had this court case of Brown versus the Board of Education. Main points of Brown versus Board of Education was an African American student in Topeka, Kansas wanted to attend school that was closer to her. I believe the school was 5 blocks away. She wanted to go to that school, but it was a school only set up for whites. The school that she was forced to go to was over 20 blocks away, and that particular school was set up only for African Americans. They sued. They sued the school board, and eventually went to the Supreme Court. The issue they wanted to address was the Equal Protection Clause again. They wanted to take a look at the 14th Amendment again and decide, was this issue of separate but equal, was it really constitutional? Okay, the school system stated that the African American school was separate but equal. Okay, so that it was allowed under the 14th Amendment. The court, taking a look at it, ruled in favor of the student and abolished the principle of separate but equal.
Mr. Clinkenbeard, dial 2101.
So that was a big deal to get rid of that principle of separate but equal. We finally outlawed that legalized segregation, and this was a monumental court case for civil rights and for the rights of African Americans. As you know, we talk about the 14th Amendment was meant to protect them, but it wasn't really doing that until the 50s and 60s came along, the civil rights movement. So once again, the significance of this, Brown versus Board of Education ended 50 years of legalized segregation, and it helped set the tone for more actions that would become the civil rights movement. And it was that time in the early 1950s, going into the 60s, when you saw the beginning of that civil rights movement, and you saw figures like Thurgood Marshall and Martin Luther King Jr. that would step in and really change the course of our country and really take the 14th Amendment and make it what it should have been, which was a law that truly did give equal rights to all citizens, and not just African Americans, but women and other minorities and whomever. And we're still fighting that battle today and trying to make sure that everyone in the United States truly is getting equal protection of the laws. So Brown versus Board of Education was a big win for people who really and truly wanted equal rights for everyone. So That's all for this video. If you have any questions, make sure to post them to the My Big Campus page under the announcements. Also, don't forget to post just a little message to show that you watched this so you can get your extra credit. Appreciate all that you guys do, and good luck on the test tomorrow.